So under section 210, I've given the reasons, you get them. Count number 1 to 17. 1 to 17. Accused persons are acquitted under section 210 CPC. All witnesses gave exculpatory evidence. In fact, apart from the IO, that is Counsel Mulki, the others gave evidence in support of the defense case. Now, they are acquitted under section 210. Counts number 18 to 31. These are basically Ms. Atkunda's clients, 34 and 35. More particularly 34, 35 relates to tax. These ones are intertwined, so accused persons placed on their defense. Again, count number 32 and 33, Mr. Mutange's client, Osiro, placed on his defense with regard to count number 32 and 33. So I repeat again, count 1 to 17, all acquitted under section 210. Counts 18 to 31, 32, 33, 34, and 35. Accused persons placed on their defense. We shall take a date for compliance with section 211 CPC. Miriam, give me the date. Clear with the last orders.
Yes, we will have you.
You saw it?
Yes, Your Honor.
You saw it?
Yes, Your Honor.
Am I clear?
Salah.
Yeah, okay. Okay.
Yes, Your Honor.
Morning, Masul.
Morning.
It's ready. It is ready. Miriam will upload it shortly. So Miriam, give me Mutange and Atkunda. A mention for
November
20?
25. 25th
Okay, fine. 25th November. Fine. 20. Okay, fine. Miriam will upload it shortly. Thank you and sorry for the inconvenience.
Most of
Is the case present in court?
Yeah, the accused.
And what about the counsel was present in court?
Yes, he's also Mr. Kachapin is here.
Oh, yes. Mm-hmm.
Yeah. I have read the directions issued by the DPP.
Yes.
By the letter dated 8 October 2025, where he has directed that the case be withdrawn under section 2 of the CPC.
Yes.
Your Honor, I'm also aware that the counsel for the complainant had written a letter dated 13th August 2025,
yes,
where he sought exemption of the complainant, attendance of the complainant.
Yes.
And I've looked at the law. Your Honor, I've realized that you have powers under Article 1, Clause 3C, as read with Article 159(1),
Article number 1.
Article 1, Clause 3C of the Constitution.
This 3C of the Constitution.
Yes, it donates sovereign powers.
Your Honor, I support those sentiments. And it's in the best interest of justice and best interest of both parties that this matter be concluded with finality.
Let us have a ruling on 20th.
And have a good afternoon.
Okay, same to you people.
Most obliged.
Will it be physical, Your Honor, or virtual?
It will be fiscal beneath.
Physical.
Okay. Prosecutor, do you-
Councils in petition E671 of 2025.
For the first
Are we done with the appearance in petition E671?
They were the second respondent to be served.
What I will represent. I'm not agreeing. It is my responsibility to give that report. I think the long and short of it, my lord, is that there is no consensus. But I think it is also important for me to put it on record on my behalf and on my behalf of all the colleagues is that there has been no attempt to generate that consensus. And I think, my lord, the reason for that is that the parties are still very far. We as respondents have certain threshold issues that we would wish the court to give direction before perhaps we can get to a point where we can sit around the table and see things in the same way as advocates for parties in this matter.
So basically we are where we are.
Yes, only that we are now in open court.
Since now I expected you to go through all the issues. They will come and tell me for this and that you have agreed, for this and that you have not agreed. So we will be able to decide this. But now you are all here. Just by giving me time. You are curious, you get nothing. You are now here, you want me, I want to go to the issue. I think what we can do then, we must have is we first must determine some of those applications that are identified. You mean you could not even agree on the issue of proposed
If I may, my lord, if my colleague will agree, that I did reach out to him to try to get him to agree to the joint land disposal, since he is the only one opposed to it. So we did do that, just for the record.
we will have to deal with the issues with the trade. Then we also have to deal with the other issue that came up yesterday that is on the joint application. There was another application. I think there is an application for extension of the one.
Yes, Your Lordship.
And there was something that
Consolidation.
consolidation. So before we consolidate, we must start dealing with the issues. Particularly the issue of building. Those way that we cannot consolidate before we deal with the issue of building. Then whether it is in which time?
My lord, E716 now.
Whether it is 716, the extension is also in 716.
Yes.
And there is also joint that is in 7. Whether it is in 716.
761, 760.
We have 761, 71,
670.
71 of 20 is fine. In E705. 705. So we have greater injury time, which we must deal with. And the other issue is, other than that failure, is the issue in certain systems you have extension of the impact orders. Is there any other issue? Then lastly, there will be consolidation. Then after that, we can do the issue of consolidation. So maybe I can give directions on providing information.
Perhaps there was also other issues of setting aside the money of not done.
Setting aside is in which time?
673 and 671.
673 or
And 671 of 20.
so that basically says to set aside the conservatory only.
Yes.
My Lord, if you may allow me,
Yes.
I believe that from yesterday's consensus was that we need to, and if we are going to be saying that let's look at the issue of setting aside of the orders, I believe that the same time frame which you are going to give us in fast tracking the petition will be consumed in these other applications. So it is my humble prayer that if we can be able to agree, you can give us 5 minutes, we can be able to agree if, that's my opinion, if we are for the main, going straight to the main petition so that we avoid time wasting in these so many applications.
Well, I think that is what we are proposed yesterday. But it appears that we need settle some of those issues.
I have read all the petitions openly, and I felt like most of those people are seeking in their petitions and in the petition, they are always the same. So on my side, I was ready to abandon the application so that we can go straight to the petition so that we can save both time.
You know, you are speaking for the petitioner. The respondents are the ones insisting that we need to find this.
Even in my law, this is a public petition, and I believe the respondents, they try to create bottleneck so that there can be delay of these petitions in the court. So I feel like with a lot of disputes, you have a lot of power to make sure that the constitution is protected by fast-tracking the issues that are in these petitions involved.
So the protection of the constitution also means.
Yes, my lordship.
So that, are you in agreement with Mr. Obonko's proposal that I give you about 10 minutes to see whether you can solve any deal?
Let's see what he has to say.
So I will leave you to speak. After 10 minutes, I'll be back.
As interested parties, they join to the matters in where they have applied to be joined as interested parties. Of the issue of conservatory orders, we have agreed, my Lord, that in petition 671 and petition 673,
Yes.
the conservatory orders adjusted such that they attach only to the amending or the amended words. The words amended into section 27(1)(b) of the Parent Act. And my Lord, those words are, or is likely to cause them to commit suicide. Or is likely to cause them to commit suicide. In respect of petition 716 from Kerguelen, we have agreed, my Lord, that the conservatory order be extended. And my Lord, that conservatory order then applied to the amendment to section 6(1)(j) of the Parent Act. Section 6(1)(j) of the Parent Act, which, my Lord, was the inclusion of the new section 6(1)(j)(a).
6(1)(j)(a).
J.A. And the J and A are in the same bracket.
6(1)(j)(a).
Yes. My Lord, we have also agreed that so as to facilitate the expeditious determination of the matters before you, the petitions that are now before you in respect of the challenge to the Computer Misuse and Cybercrime Act be consolidated.
So which will be the lead file?
The lead file, I believe, is the first in time. 671? And the parties will be rearranged accordingly. Where there is any repetition of parties, that will be taken into account. My Lord, we have agreed that so as to again facilitate the expeditious disposal of this matter, parties frame their issues. And file those issues in court. And from the issues filed by the various parties in these matters, my Lord, the court can then indicate the issues for determination. Once that is done, my Lord, the parties can then file their submissions in respect of those issues. And my Lord, we can return as soon as next week, of course, at your convenience, to highlight our submissions. My Lord, I had forgotten the one issue, and it isn't an issue that we have discussed, but I can perhaps make the proposal loudly to my colleagues, that any party who has not responded to liberty to respond again as soon as possible. That, unless my learned colleagues will correct me if I've forgotten anything, is the extent of the conversation that we had in the time we left the
Yes, sir, Shonas, I also wish to seek leave for us to put in any supplementary affidavits.
It's not that easy in the position, and we understand you'll be away for some time.
You have really saved me a lot of agony in this.
But my Lord, I had echoed it may not be appropriate to me if you can be able to accommodate us next week but one, which is still not very far away from next week. Because next week I'll be having exams, which I cannot be able to postpone.
Yes, that's Mr. Kipron.
Yes, my lord, petitioners in 705. Indeed, that is a consensus that was made. And we also would like leave to file additional affidavits.
And remember, you have not served the DPP.
In fact, serving this afternoon.
No, I don't know whether I should reduce this, if we go and do them and post them on the CTS.
My proposal would be okay, and also because we need the arrangement of the parties. The court can be kind enough to let us do that, because it has the benefit of all the sides.
Yeah, I think I'll just go and reduce them into something like a proper directions based on your consent, and then they'll be typed and uploaded on the CTS. That would be. And then when do you come next now? Because now my leave starts next week, and it's a long one.
There is here.
Should be allowed to file, like there are those who may not have filed their responses, they might want time to file their responses. Then there are those who want to file their further affidavits. What is the time that you are looking at to do that?
My lord, we can do it by Monday.
So those who have not filed responses can file them by Monday, isn't it? And then those who have not further affidavits, by which date? By Tuesday.
By Tuesday.
So Annette, we can hear them on which date? So does it mean that at the time you file responses and also you file your submissions?
Yes.
Everything?
Yes.
Then that is okay. Okay, my proposal is the next week is extremely packed for me, but on Friday I have 2 benches. I don't know whether they can extend up to afternoon session, so we can meet or convene at around what time? 2. Maybe we mention the matter at 2 p.m. virtually. 2 p.m. So that I'll have done my benches. Then I'll see whether now that Friday afternoon can be okay for us to meet virtually. Friday afternoon. I'll have benches in the morning. Then in afternoon we can have this one. We can mention this one virtually, just to confirm compliance and then give further directions. Is that okay? Yeah.
So just a clarification, Friday afternoon is for compliance or for the possibility of highlighting?
Highlighting will not be possible because I've been in court the whole day. I've been in court in the morning, the first and the second bench, and then I'll meet you in the afternoon.
That is understood.